President Trump announcing he will implement what he calls a 15% global tariff on all countries. This comes after the Supreme Court ruled against the tariffs he put in place under the use of the International Economic Emergency Powers Act. Madeline Rivera joining me now with the latest reaction from other world leaders. Hi, Maddie.
Good morning, Aisha. Good afternoon, Aisha. World leaders are generally treating the Supreme Court's ruling with cautious optimism. The deputy chief spokesperson of the EU Commission had this to say on X. "We take note of the ruling by the U.S. Supreme Court and are analyzing it carefully. We remain in close contact with the U.S. administration as we seek clarity on the steps they intend to take in response to this ruling." So that statement reflecting the feeling of uncertainty in the wake of this high court decision, because the president is making it clear he's not dropping tariffs immediately. Instead, he's pivoting, turning away from the International Emergency Economic Powers Act that the high court decided he could not use. And one of the trade laws he's now leaning on is Section 122 of the 1974 Trade Act.
What's up, guys? You're tuned into Dr. John. Trump sat in the Supreme Court gallery to hear arguments on his executive order, then walked out without ceremony. The image became the defining moment of his relationship with the constitutional system he had sworn to defend. Within minutes of exiting that hallowed courtroom, Trump's thumbs were flying across his phone, unleashing a Truth Social tirade that would have shocked the founders. He wasn't just criticizing the court's potential ruling or questioning the legal arguments he had just heard. He went straight for the jugular of American constitutional law itself. He called the 14th Amendment's birthright citizenship guarantee a sign of national stupidity, insisting that America should not be foolish enough to allow such a provision to stand. Let that sink in for a moment. The President of the United States had just spent 60 minutes watching the highest court in the land deliberate on whether his interpretation of the Constitution could hold water.
And in a sign of how the president is doubling down, he announced this morning he's raising the 10% worldwide tariff on countries to 15%. But there's a caveat. There's a 150-day limit under the statute unless Congress votes to extend it.
It is quite clear in the Constitution explicitly that it is Article 1, the legislative branch, the Congress, that has the power to tax, has the power to tariff. This is now an opportunity for Congress to reassert itself as a co-equal branch of government.
In its decision, the Supreme Court did not address how the government will now return the roughly $175 billion in tariff revenue it says it's collected. Hundreds of businesses are already calling for quick and automatic refunds. Administration officials acknowledge the process will likely be mired in litigation and take years, but officials are more optimistic about the trade deals and framework agreements that they've struck.
Those agreements hold. Those agreements will remain. We'll honor them. We expect our trading partners to honor them.
The new 15% tariffs are expected to take effect.
Okay, Maddie, thank you very much. For more on President Trump's reaction to the ruling on tariffs, let's welcome in Fox News contributor and host of the Hugh Hewitt Show, Hugh Hewitt.
And the moment he stepped outside, he dismissed that same constitutional provision as something only a fool would support. Are you kidding me? This wasn't a policy disagreement. This wasn't a legitimate constitutional debate. This was the nation's chief executive looking at the foundational document of American democracy and calling it stupid. The arrogance, the audacity, the sheer contempt for the constitutional order that he had sworn to uphold. This is the specific image that captures something profoundly important about the Trump presidency and its relationship with the constitutional system he is supposed to lead. The willingness to enter the institution, observe its careful proceedings, and immediately express contempt for the very constitutional text it was interpreting. That walkout moment is connected to a broader pattern that has been building throughout his second term.
Great to have you on. I think the biggest question for everybody now moving forward, because you can't go back, right? You can't go back and argue with the Supreme Court. The big question is, what happens to the $175 billion that the U.S. made off of these tariffs? You've got Democrats like J.B. Pritzker that are already saying, give me back my money. And I imagine that these lawsuits are going to go on for months and months and months. So is this a problem for the president and this White House ahead of the midterms?
Good afternoon to you, Aisha. I don't think so. It goes back to the Federal Court of Claims. It was remanded to the appeals court, which for further proceeding consistent with the opinion. So I don't think it's going to be a problem in the midterm. I doubt very much if people will remember it at all in the midterms, because it is such, the most important thing is being overlooked, which is President Trump instantly complied. He's very angry with the court. He wanted to use the IEEP, but he instantly complied. He's not an authoritarian. He's not a fascist. He's a president in a republic of law. And the co-equal branch, separate but equal, gets charged with making a decision. 7 different opinions, all saying we are basing our ruling in common sense. Now, I've been teaching common law for 30 years.
A pattern where the judges and justices who are supposed to serve as neutral referees of constitutional questions are no longer staying silent about what they are witnessing from the executive branch. Something fundamental has shifted in the relationship between the White House and the judiciary, and the people who wear the black robes are finally speaking up about it. Justice Ketanji Brown Jackson delivered an 18-minute speech at a judicial conference in Puerto Rico that she explicitly described as addressing the elephant in the room. She didn't mince words. She didn't wrap her concerns in careful legal jargon. She looked her fellow federal judges in the eye and told them exactly what she thought was happening to their institution. Chief Justice John Roberts issued a rare public statement warning that personal attacks on judges are dangerous and absolutely must stop. And when the Supreme Court ruled 6-3 that Trump's signature tariff program was illegal, the president went ballistic on social media.
This is going to be a nightmare to teach because when everyone claims common sense, that means it's a pretty ambiguous statute that requires people to deal with it. But it'll go back to the Court of Claims. The Court of Claims will get all sorts of different demands from consumers, from companies, exporters, importers, and the case law is going to go on for a long time. But I don't think it matters. All that matters when it comes to the midterms is how is the economy doing? And although the economy slowed a little bit in the fourth quarter because of the government shutdown, it's cooking. The president is right. It's very hot. And I don't think it's going to matter much come November.
Yeah. Well, I want to get to the economy in just a second, but one more on the Supreme Court justices, particularly because the president is really mad. And Kim Strassel, I think, put it really well yesterday when she said the biggest win, the victory here, is that you take away the Democrats' argument that the president or the Supreme Court is somehow in the president's pocket. So you can't say that anymore. But he didn't hold back when he was talking about the justices, even the ones that he has appointed. Let's listen together.
What a shame. Having to do with voting in particular.
Calling the justices who voted against him fools and lapdogs, and saying that his own appointees, Gorsuch and Barrett, sicken him and are an embarrassment to their families. Can you believe this? The President of the United States calling Supreme Court justices fools and lapdogs and embarrassments to their families. This is absolutely wild. Let's talk about what that relationship actually looks like from inside the institution and why the justices and judges who are speaking up are doing so in the specific way they are. The Supreme Court's ruling on tariffs clearly disappointed the president beyond measure. He publicly expressed shame at certain members of the court while simultaneously praising Justices Thomas, Alito, and Kavanaugh for what he called their strength, wisdom, and love of country. But the language he used for the other 6 justices was vicious.
When in fact they're just being fools and lapdogs for the rhinos and the radical left Democrats, and not that this should have anything at all to do with it. They're very unpatriotic and disloyal to our Constitution.
I mean, Hugh, I imagine it's going to be a very awkward State of the Union address when those justices are sitting right smack dab in front of him. And he might mention this.
Well, he might. Remember that President Obama called out the court over Citizens United, and he got the law wrong, and Justice Alito mouthed, "That's wrong." So it would not be the first time. But now they have some Trump tattoos. Only last year, the Supreme Court ruled broadly in favor of President Trump's claim of immunity. So sometimes you win, sometimes you lose. Justice Scalia wrote a very famous opinion, Aisha, called Employment Division v. Smith. It makes everyone who loves Scalia, including me, angry every time we read it because it's so wrong. So the deal with the American constitutional system is you're never going to bat 1,000. You're never going to get your way and the way that you've argued the case. But you always accept the bottom line. The decision is always and immediately accepted because the Supreme Court gets the final word. The president, however, I love your term, he never holds back, and that is refreshing.
He accused the Democratic appointees of being automatic no votes, claiming they oppose anything that makes America strong, healthy, and great again. He called them a disgrace to the nation. This wasn't a president expressing disagreement with judicial philosophy. This was a president attacking the very legitimacy of the court's decision-making process, suggesting that the justices were motivated not by constitutional interpretation, but by partisan loyalty. And then came the really personal stuff, the attacks on his own appointees that crossed every conceivable line of decency and respect for the institution. Gorsuch and Barrett had been his picks. He had put them on the court, and because they had the audacity to rule according to the law rather than according to his political preferences, he turned on them with a ferocity that stunned even his most loyal supporters. Now let's examine Justice Jackson's speech in full context, because the specific language she used and the specific audience she was addressing make it the most significant public statement from any member of the federal judiciary about the relationship between the executive and judicial branches in recent memory. She wasn't speaking to a room of law students or delivering a carefully worded lecture at a university. She was addressing working federal judges, people who were experiencing the consequences of Trump's attacks on the judiciary directly and personally. Some of these judges had received threats against their lives. Some had faced calls for their impeachment by members of Congress who were echoing the president's attacks. Some had been the subject of the Department of Justice's internal list identifying judges whose rulings the administration considered most obstructionist to its agenda. These were not abstract legal concerns. These were real people facing real pressure from the most powerful executive branch in American history. Jackson opened her remarks by saying she was going to address the elephant in the room, signaling immediately that what she was about to say was not a standard conference speech about legal doctrine or judicial administration. She then described what she characterized as relentless attacks, disregard, and disparagement that judges around the country were facing on a daily basis. She said the attacks are not random. They seem designed to intimidate those of us who serve in this critical capacity. The threats and harassment are attacks on our democracy, on our system of government, and they ultimately risk undermining our Constitution and the rule of law. She called on judges to show raw courage and told them that history will vindicate your service. In the room filled with federal judges who had been living under the pressure of the administration's judicial intimidation campaign, she received a standing ovation. A Supreme Court justice speaking to a room of federal judges and receiving a standing ovation for telling them that the attacks they were experiencing were designed to intimidate them. That is absolutely unprecedented. And that speech was a direct and documented response to a documented campaign by the administration to pressure, impeach, fire, or replace judges who issue rulings it disagreed with. Then came the tariff ruling. The 6-3 Supreme Court opinion struck down Trump's entire tariff architecture as illegal, and with it came the president's most extreme public reaction to any Supreme Court ruling in his career. The majority included Roberts, Sotomayor, Kagan, Jackson, Gorsuch, and Barrett. Two of Trump's own appointees, Gorsuch and Barrett, voted against him. Trump's response was immediate and extraordinary. He called the justices in the majority fools and lapdogs. He suggested they were compromised by foreign influences and used the word slimeballs. And then he singled out his own appointees, the two justices he had put on the court himself, and said that Gorsuch and Barrett sicken him and that they are an embarrassment to their families. Justices of the United States Supreme Court, people who hold lifetime appointments, who have dedicated their entire careers to the law, who were confirmed by the United States Senate after extensive hearings, were being called sickening and embarrassments to their families by the president who appointed them. This is beyond belief. The same week that Justice Jackson had called for raw courage in the face of attacks on the judiciary, Trump was publicly saying that his own Supreme Court appointees sicken him for ruling on the law rather than on personal loyalty. That is the specific collision this story is about. The significance of Jackson's speech extends far beyond its specific words. It signals that the federal judiciary, or at least significant parts of it, has reached a point where the institutional norm of public reticence about political matters is being overridden by the institutional need to publicly defend the institution's independence. That is a profound development in the relationship between the executive branch and the judiciary. The fools and lapdogs language that Trump used after the tariff ruling reveals something specific about his model of what justices are and what they owe him. Fools and lapdogs are not policy criticism terms. They are terms that describe incompetence and subservience. Calling justices fools says their intellectual capacity to evaluate legal questions is inadequate. Calling them lapdogs says they are serving the interest of whoever is holding the leash. And the implication is that the proper leash holder is not the Constitution, but the person Trump identifies as compromising them. The foreign influences and slime balls he references. And then the sickening and embarrassment to their families' language for Gorsuch and Barrett goes even further into personal condemnation of two people he elevated to lifetime positions on the nation's highest court. The embarrassment to their families' formulation is specifically personal in a way that nothing else Trump has said about justices has been. It is not a critique of their legal reasoning. It is not even a critique of their character as jurists. It is a statement about their relationship with their own families, suggesting that their families are ashamed of them for the decision they made. That is not political criticism. That is a personal attack on a deeply intimate level. And the target of that personal attack is two sitting Supreme Court justices who exercise the exact same independent judgment that their confirmation hearings promised they would exercise. Their only offense was applying the law as they read it rather than as Trump needed it to read. A president calling two of his own Supreme Court appointees embarrassments to their families because they ruled against his tariff program. That language is the specific documentation of a president who does not understand the independence of the judiciary as a constitutional feature. He understands it as a personal betrayal. Now let's examine the birthright citizenship courtroom visit and walkout, because this episode is the most physically symbolic moment in the deteriorating court-executive relationship, and one that most directly illustrates Trump's approach to constitutional limits as a spectator rather than a participant. Trump attended Supreme Court oral arguments on his birthright citizenship order, reportedly sitting in the public gallery reserved for members of the public who come to observe proceedings. No sitting president had done this in modern American history. The courtroom has a specific physical and ceremonial structure designed to reflect the court's institutional authority. The justices sit at an elevated bench. The proceedings follow specific formal protocols. The gallery is silent. Trump sat in that gallery for a little over an hour and then left. And within a short time of leaving, he posted on Truth Social attacking the 14th Amendment, the constitutional provision at the center of the birthright citizenship case. The court had just been discussing the 14th Amendment Citizenship Clause, which says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That language has been interpreted to guarantee birthright citizenship to virtually all people born on American soil for over 150 years. Trump's order sought to change that interpretation through executive action. In his Truth Social post after leaving the courtroom, he said the United States should not be stupid enough to allow birthright citizenship. The court he had just been sitting in was at that moment evaluating whether his order was constitutional. He left and immediately called the constitutional guarantee that his order challenged stupid. That is the specific dynamic this story describes. A president who enters the institution and then expresses contempt for the constitutional text the institution is interpreting the moment he leaves the building. Sitting in the Supreme Court gallery for an hour watching the court consider his own order, then walking out and calling the constitutional provision at issue stupid. This is not how a president is supposed to behave. Chief Justice Roberts' warning is the third dimension of this story because it is the institutional response from the person who most represents the court's own understanding of its role and whose voice carries the most institutional weight in any public statement about judicial independence. Roberts is the Chief Justice of the United States. That title is not merely ceremonial. He is the presiding officer of the Supreme Court. He is the presiding officer of the entire federal judicial branch. He is designated by statute as the head of the federal judiciary, not just the head of the Supreme Court. He is the person most directly responsible for the institutional reputation of the courts, for their public credibility, and for the relationship between the judicial branch and the other branches of government. And Roberts has been extraordinarily careful throughout his tenure to avoid the appearance of political involvement, to maintain the court's reputation as an institution above partisan battles, and to resist commenting publicly on political controversies in ways that might compromise that reputation. His March 2025 statement, issued specifically in response to Trump's calls for the impeachment of a judge following the deportation flights controversy, was therefore a significant departure from his normal reticence. He said directly that it is not appropriate to threaten judges with impeachment over their decisions. He said the normal appellate review process exists for that purpose. He said personal attacks on judges have got to stop. He framed these attacks as dangerous. That statement from the Chief Justice in his official capacity on the specific question of whether the president's conduct toward the judiciary was appropriate was a direct institutional rebuke. Not a political statement, not a partisan criticism, but a constitutional statement from the head of the judicial branch about the conduct of the head of the executive branch. And when Roberts then joined the 6-3 majority in the tariff ruling, writing the majority opinion that said those words cannot bear such weight, he completed the picture. The Chief Justice was not just warning about executive attacks on the judiciary. He was ruling against the executive's claim of authority in the most important separation of powers case in years. Both actions, the warning and the ruling, come from the same institutional commitment. The judiciary exists to apply the law independently. Roberts was doing exactly that on both fronts simultaneously. Let's really understand what's happening here. Jackson's elephant in the room speech is the most significant public statement from a sitting justice about the political environment for the federal judiciary in modern American history. The norm of judicial reticence about political matters exists for a specific reason. It is supposed to insulate the judiciary from the appearance of partisan involvement and protect the court's credibility as an institution above politics. When a sitting Supreme Court justice breaks that norm in the specific way Jackson broke it, delivering an 18-minute speech at a judicial conference that describes executive attacks on the judiciary as designed to intimidate and as attacks on democracy, she is making a specific institutional calculation. She is concluding that the threat to judicial independence from staying silent is greater than the threat to the court's institutional credibility from speaking. That calculation reflects a judgment about the severity of what is happening to the federal judiciary under the current administration. It is not the judgment of a justice who is frustrated about being criticized. It is the judgment of a justice who has concluded that the federal judiciary as an institution is experiencing something qualitatively different from ordinary political tension, something that requires extraordinary institutional response. And the standing ovation she received from a room of federal judges suggests that her assessment of the severity of the situation resonates with the people who are experiencing it most directly. Calling Supreme Court justices fools, lapdogs, sickening, and embarrassments to their families is the most direct assault on judicial independence from any American president in modern history. Trump has historically attacked judges who have ruled against him. He attacked a district judge in 2016. He attacked what he called the Obama judge who ruled against him in 2018, producing Roberts' first judicial independence statement. He called another judge a certified Trump hater. He called another a radical left lunatic. All of those attacks were on lower court judges. The tariff ruling produced the same attack directed at Supreme Court justices, including his own appointees. That escalation from attacking the judges who rule against him generally to attacking the Supreme Court specifically, and from attacking judges appointed by the other side to attacking his own appointees for ruling independently, represents a qualitative change in the nature of the attack. It says that there is no appointment, no confirmation, no lifetime tenure, and no level of the federal judiciary that is immune from personal attack when the ruling goes against him. And it tells every future potential Supreme Court appointee what the implicit expectation of the appointing president is. That loyalty to the appointer should factor into legal judgments in ways that the Constitution explicitly did not design it to. The birthright citizenship walkout is the most physically evocative symbol of the administration's approach to constitutional limits and deserves to be understood in its specific constitutional context. The 14th Amendment Citizenship Clause is one of the most clearly written provisions in the entire Constitution. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That language was written specifically and deliberately to overturn the Dred Scott decision, which had held that Black Americans were not and could not be citizens, and to guarantee that citizenship will be determined by birth rather than by race or ancestry. The provision has been in the Constitution since 1868 and has been interpreted consistently to guarantee birthright citizenship for over 150 years. Trump's executive order sought to change that interpretation without a constitutional amendment through executive action alone. He came to sit in the gallery of the court that was evaluating whether that executive action was constitutional. He left and called the 14th Amendment provision stupid. The specific word stupid applied to a provision of the United States Constitution is the distillation of the pattern Jackson described in Puerto Rico. A president who treats constitutional limits as personal affronts rather than as foundational laws, and who expresses that contempt publicly in a way that is unprecedented in American political history. The mutual contempt between Trump and the judiciary has created a constitutional standoff that has no clear resolution mechanism in the immediate term. Trump has contempt for the judiciary when it limits him. The judiciary has contempt for his attacks and is increasingly saying so publicly. And the constitutional design does not provide a direct mechanism for resolving that standoff. It provides indirect mechanisms like the impeachment of the president, the appellate review of lower court decisions, and the appointment of new justices, none of which directly address the current dynamic. What the constitutional design does provide is institutional resilience, the capacity of the judiciary to keep functioning as an independent branch despite executive pressure, because judges have lifetime tenure and cannot be removed for their decisions. Jackson's raw courage call and Roberts' personal attacks have got to stop statement are both expressions of that institutional resilience. They are the judiciary saying, we are aware of the pressure, we understand what is being attempted, and we are going to keep doing our jobs anyway. The birthright citizenship case will be decided on the constitutional merits. The war powers cases will be decided on the constitutional merits. The next challenge to the next Trump executive order will be decided on the constitutional merits. And Trump's social media reactions to those decisions will be what they are, documented public expressions of contempt for the constitutional system that will exist in the permanent record of this administration. Why this all matters going forward. The relationship between the Trump administration and the federal judiciary has moved from the normal political tension that exists in every single administration into something that multiple sitting and retired members of the judiciary have publicly characterized as an unprecedented threat to judicial independence and to constitutional governance. Jackson's speech, Roberts' statement, the 140-plus retired judges who signed a collective warning, the 2 Trump-appointed appeals court judges who testified to Congress that the judicial intimidation campaign was inappropriate and dangerous. All of those are documented institutional responses to a documented campaign of executive pressure on the judicial branch and the Supreme Court itself. The 6-3 tariff ruling, the Roberts majority opinion saying those words cannot bear such weight, the Gorsuch and Barrett votes against their appointing president, is the institutional response through the one mechanism that matters more than any speech or warning. The law applied independently by justices who serve the Constitution rather than the president. Trump called them fools and lapdogs. History will call them the court that said no when the president needed to hear it. And the raw courage that Jackson called for in that room in Puerto Rico to a standing ovation from federal judges who had been living under the pressure of the campaign she was describing is the quality that the constitutional system depends on. It is judges having the courage every time they sit down to write a ruling that the person in the Oval Office is not going to like. That is what judicial independence looks like. That is what the Constitution demands. And that is what Trump cannot seem to understand or accept. The system held, the court did its job, and the president's contempt for both could not change that fundamental reality.